US versus EP patent interviews, phrasing differences that win. Welcome. Today we'll compare how to speak with examiners in the US and the European Patent Office, EP. The goal is the same: clear, productive prosecution conversations that move your case forward. But norms differ, and those norms shape what questions land well. In the US, direct, solution-seeking phrasing is expected. In Europe, neutral, evidence-led language earns trust. Your wording signals strategy, respect, and awareness of each office's framework. Mastering these differences helps you avoid friction, surface real agreement, and capture it properly in the record, without making unwanted concessions. Let's turn small phrasing shifts into big prosecution wins. In US interviews, be clear and decisive. Start by stating the problem. The 102 rejection relies on Smith for feature A. Then propose a targeted amendment that addresses it. Ask directly for allowable subject matter. Which claim set appears allowable given the current art? Use hypotheticals to test scope. If we add feature X to claim 1, would that overcome the 103 based on Smith plus Lee? These concrete proposals let the examiner react quickly, narrow issues, and signal a path to allowance. Keep it practical. Identify the obstacle, propose a fix, and check whether the fix actually clears the rejection. In EP calls, align with the problem-solution approach. Frame discussions by identifying the closest prior art, the distinguishing features, and the objective technical problem. Request the examiner's preliminary view rather than pushing text. Could you outline the distinguishing features over D1 and any obvious combinations? Avoid negotiating claim wording too early. Instead, seek fact patterns and technical effects that can be backed by the application or post-published evidence, where admissible. The tone is neutral and analytical. Map facts first, then reason to conclusions. This shows respect for the EPO's structured analysis and protects you from premature concessions. Notice how request phrasing shifts by system. US style: what amendment would overcome 102? This invites a practical fix and pins down a path to allowance. EP style: which distinguishing features are acknowledged over D1? That asks for fact-finding before solutions, consistent with the EPO's method. The mindset moves from fix-seeking to evidence mapping. By clarifying the factual baseline first in Europe, you avoid debating text that might not address the actual differences. In the US, going straight to the amendment proposal efficiently tests whether you've solved the examiner's stated concern. US phrasing often probes outcomes. If we add X, is it novel/non-obvious? That's fine. Stateside. In the EP, ask, what is the objective technical problem when feature X is considered? Then tie X to verifiable technical effects. Does X improve stability or reduce latency? And is that effect derivable from the application? The EPO wants a chain. Distinguishing features: right-pointing arrow technical effect, right-pointing arrow objective problem, right-pointing arrow non-obvious solution. Linking effects to evidence helps secure inventive step. In short, US checks allowability with amendments. EP builds a reasoned narrative from facts to technical results. For the US, discuss motivation to combine and rationales. Where would a skilled person find reason to combine Smith and Lee? Probe teaching away, or lack of reasonable expectation of success. In the EP, first map features to D1, D2. Which features come from D1 and which from D2? Then ask for closest prior art confirmation to anchor the analysis. Only after mapping should you debate obviousness using the problem-solution framework. This prevents talking past each other and ensures your arguments align with the examiner's structure and evidence. Tone matters. In the U.S., be decisive and aim to confirm agreement on the record. Summarize the amendment and the examiner's indication of allowability. In the EP, be cautious. Avoid binding concessions or locking into unneeded limitations. Summarize facts, not promises. Key trap: don't import claim construction across systems. A term interpreted broadly under U.S. standards may be read differently at the EPO. Keep definitions jurisdiction-specific, and never overstate technical effects unless they're supported by the application or accepted by the examiner. Before a U.S. call, set the goal as allowance. Prepare concrete amendments, fallback positions, and clear hypotheticals. Before an EP call, set the goal as clarity of objections. Prepare a comparative feature chart against D1, D2, candidate effects, and where support sits in the application. During the call, confirm points of agreement, items needing evidence, and any next searches. After the call, send a short written confirmation. In the U.S., capture the amendment path. In the EP, capture the distinguishing features, closest prior art, and the examiner's preliminary view on the objective technical problem.